You've just been involved in a self-defense shooting and you're going to call 911. What should you say? What shouldn't you say? Stand by. We're going to break it all down for you today. This is attorney Andy Marcantel and attorney Marc J. Victor. We're the partners at the Attorneys for Freedom Law Firm here today to answer some questions that a lot of viewers have had for us over the years. How you doing, Marc?
Fantastic. I love doing these videos. I say it every time we do these kinds of videos. These are definitely my favorite kind of videos to do because it allows us to do our favorite thing, which is to be criminal defense lawyers.
That's right. I also love the fact that it's like super practical. I love making practical videos that people are like, oh, okay, like that's a question I always had that maybe I don't know a lawyer in my own life, and I'm just wondering what a lawyer's opinion on this would be. I love making these videos.
Plus, it's always like the backdrop here is like, how many cases have we had over the years that would have turned out better for our client if they had heard in advance the things we're going to say in this video?
Absolutely. Yeah, I think that's a really good point. All of the advice that we're going to dispense today has been painstakingly crafted and chiseled and refined based on thousands of cases that we have done. So, I mean, you're about to get the collective knowledge of all these cases that we've done, many, many different scenarios that we've seen, and that's why we're going to give you the advice that we are today.
Yeah, and I think this actually is a really good place to start, because if what you're looking for is the perfect piece of advice for how to deal with that 911 call in all situations and everything that could come up, sorry.
Spoiler alert, it doesn't exist.
No, it just doesn't exist. And it's because there's an infinite number of factual circumstances that could arise, right? I mean, we think about the shooting case. I just shot somebody and now I'm thinking about calling that. Well, but okay, that's one example. And then, of course, there's a limitless number of factual circumstances you could graft onto that. But then there's the circumstance where I pulled out my firearm and maybe I pointed it at someone and said, hey, you better leave or stop or whatever. And then you didn't shoot, but then they left. There's that situation too. There's, maybe you didn't pull out a firearm. You showed a firearm. You displayed a firearm. You said you had a firearm. Then there's you used a knife. There's you got into a fist fight with somebody. There's all these different. There were witnesses. There were no witnesses. The person is injured in your home. The person is injured but jumped in their buddy's car and drove away.
Yeah, not only where the incident took place, but where people ultimately ended up, right? Because our advice is going to change drastically if, say, you had to shoot somebody or injure somebody while they were on your own property, maybe trying to break in, but then they left and jumped in a car and went away. We're going to have very different advice than if they had collapsed on the floor of your property.
Plus, there's the other part of the equation. There's who we're giving the advice to. People aren't all equally situated. Some people are more sophisticated than other people, right? And that makes a big difference, right? The more sophisticated you are, the more sort of nuanced we can be in what our advice is. Also, there's how stressed are you? You may be very sophisticated.
People have different stress tolerances, and you and I have talked to many people directly after emergency situations, and some can stay kind of fight or flight, calm, cool, collected, everything like that, and get what needs to be done. And some people are just falling apart at that point. So not everybody's the same here.
And then there's situations where nobody saw what happened. So whatever you say on that call, that's going to be the evidence. And then there's situations where, 10 people saw what happened. It's on a video. I mean, it's completely different circumstance. And then, of course, there are the things some people don't like to talk about when they talk about these kinds of situations. I mean, lots of people like to assume, this is a huge assumption, that you're in a good shoot or you were in a valid act of self-defense. And we all like to pretend that because we're responsible firearms owners and we've had training and we've thought about this in advance, that anytime you get involved in what you classify as a self-defense incident is going to be a justified act of self-defense. That's not always the case. You might have thought you were acting in self-defense. You might have intended to act in self-defense, but you might have blown it. You might have screwed it up. And there are slight differences in the laws in the different states, right? I mean, what's sort of the famous example is in Texas, there's this statute that allows you to actually use deadly physical force in certain circumstances to protect property. Okay, that doesn't exist anywhere else.
Doesn't exist anywhere else in the United States.
So there are all kinds of different situations that come up. In fact, I had a debate with Massad Ayoob on this very point, right? He has advice, and he talks about after the self-defense incident to talk to the police, and he wants you to make a short statement. In fact, maybe we can put a link to that video, the debate that I did with Massad on this very issue. And if people watch that to the end, what they'll find is he assumes that the self-defense incident is justified. I mean, he actually says that during our debate where he says, look, I'm assuming that the person I'm talking about or that I'm talking to is taking my course and is following my advice, and they're not in a bad shoot. And then sort of the implication here, and with so many people in other programs, the implication is you're acting in a justified way. And if you're not, well, that's not our problem. We're not worried about you. And you might say that. People watching this video might say that's true. Who wants to protect the criminals? Until it's you.
Right.
Until you made a bad split-second decision in a very stressful circumstance. And like we like to say over and over, you don't get to select the time at which you're dealing with this kind of a threat. And then we paint a picture. Maybe it's at 2 o'clock in the morning.
2 o'clock in the morning.
You're in a
sleepy,
dead sleep. You had a
you're
big party.
groggy,
You had a big party at your home that night.
You're hungover.
Yeah,
maybe still drunk.
Yeah, you may be still drunk. I mean, who knows what's going on? You might have made a bad split-second decision. Do you want a program, and do you want people that you're dealing with who are going to say, you made a bad decision. Screw you. We're not worried about you.
I think that's a valid critique of all of the other programs on the market outside of attorneys on retainer, which is that the reason why you're getting this program? In the event of like a perfect shoot, you perfectly execute it, well, then why do you need the program? Because it's very, very rarely going to be that instance in which you're going to be prosecuted. They're prosecuting bad shoots for the most part.
Yeah, I mean, as we've said on many occasions, there's the Rittenhouse situation. There are a few high-profile examples where you can look at this and say, yeah, the person did act in a way that we can look at and say this is justified self-defense, and they still got charged.
Right.
Like, that happens, but not very often.
The Rittenhouses of the world, that's the exception to the rule.
That's
The
right.
vast majority of these cases are not politically charged and don't have tons of media coverage and political ideologies swirling around them. And most of the times, prosecutors will not take cases and won't charge cases that they know are likely to fail or lose.
These prosecutors, they're not idiots. They went to law school. They do these cases. They have access to experts. They've looked at the video. They've reviewed the evidence, the statements, and they have concluded if they're going to charge the case, there is a reasonable likelihood of a conviction, or they presented it to a grand jury and a sufficient number of randomly selected people from the local community. Does that sound familiar? Those are the same kind of people going to be on your jury. They think there is probable cause to charge this case, which is to say they reject the idea that this is a valid shoot. So if you're charged with a crime, you're probably dealing either with the situation where you screwed it up, it's a bad shoot, or could go either way. It's what we call the arguable shoot. I mean, there's arguments that it's justified. There's arguments that it's not justified. At the end of the day, that's going to be the question. Ladies and gentlemen, now that you've seen and heard and reviewed all the evidence, tell us, did the defendant act reasonably? Yes or no? If the answer yes, defendant goes home. If the answer no, defendant goes to prison, usually for a long time.
All right, so before we get into our specific advice, I want to throw one more thing out there at the onset, which is that so many times in our cases, I don't know how many times, countless times you and I have said this to each other, Mark, where it's like, wow, the worst piece of evidence in the entire case came directly from our own client's mouth when they decided to either talk to 911 or talk to the cops or make a quick and brief thinking, this would help me. I'll make this statement and I'll improve my situation. You want to say anything about this, Mark? I mean, how many times have we sat down with a client and said, had you just shut up or kept it more brief or, not said this or that, we'd be looking at a totally different case here.
After practicing 30 plus years, I know that I'm coming across a little cranky sometimes. We're sitting in the office and we're talking, and I'm frustrated. I'm like, why did you open haven't you heard the advice of virtually every criminal defense lawyer who has spoken on this topic? It's some version of just shut up. How quickly exactly, and what little few things you say before you just shut up. Okay, that's what we're talking about today. But everybody is in unanimous agreement. shut up. Less is better. And so, yeah, it gets frustrating. I'm sitting there and I'm thinking, man, if you had just shut the heck up.
See, but this is what people normally associate with when law enforcement show up, right? The educated folks know, okay, I'm not talking to law enforcement. I'm going to just shut up. But what I think we're really trying to transpose here as a general principle is take that same mentality where you're protective against law enforcement when they arrive at a scene and apply those principles to the initial 911 call. Super duper important. And not all attorneys are as uniform on this one. Mark, you and I just watched a video. In fact, this is from our friends, people we like very much, by the way, over at the Armed Attorneys. They made a video where they gave their advice on what to say and what not to say during the 911 call. And there was a part of that video where as soon as we were watching it together, and as soon as it came on the screen and they gave this piece of advice, you and I both kind of cringed and looked at each other and said, ooh, no, not at all. And what that piece of advice was, give a short, factual, truthful statement about the incident. And we were just both facepalm at that point.
Yeah, I mean, look, just to put it all out on the table, we like Richard and Emily. We've spoken to them, and we have nothing but great respect for them as fellow brother and sister criminal defense lawyers. We support them. We're big fans. We're on the same side. We watch their channel. We like those guys. Now, Emily wasn't part of this particular video. They had another lawyer there who I hadn't met before named Edwin. And yeah, we watched that video. And again, under the backdrop of, it's hard to give advice that applies to every situation perfectly, but we both cringed at the same time. They talk about, okay, identify yourself. We don't love that either.
No,
right?
I'm not a huge fan of that. Yeah, that's kind of rule number one there is say who you are. You need to truthfully say who you are. I disagree with that in many situations. Remember, and people got to keep this in mind, the state has to prove their case beyond a reasonable doubt.
Every aspect.
The burden is on the state. And what's one aspect of the case? Who's the shooter? Maybe they can't prove who's the shooter. Maybe that you're having a friend over. Maybe it's a family member. Maybe it's somebody else. Maybe it's somebody walking by. Maybe it's somebody who also broke into the house. There are a million different scenarios. Who knows what the evidences support? Why give up this element?
It's a bit of a segue, but it's kind of a fun story. I once won a trial by putting my client, the defendant, in the back of the courtroom, and I had him sort of reading a magazine during the trial. And then I took my investigator, who maybe looked a little bit like the defendant, and I stuck him next to me. I didn't identify him as the investigator. I just stood up and I said, Marc Victor on behalf of, and I named my client. And I said, who was present in the courtroom. And the reason I did this was because I didn't think that the state could prove identification. And sure enough, the police officer went up there and pointed out the guy sitting next to me who had absolutely nothing to do with the case and said, that's the guy I remember. That's the guy I arrested. He was the one involved in the incident, blah, 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 blah. And of course, we went at halftime. A motion for judgment of acquittal after the state rested.
Rule 20 motion.
Yeah, it was a Rule 20 motion. I stood up and said, hey, they can't identify my client, and he's here in the courtroom. And we won on the issue of identification. Why would you want to give that up? I mean, sometimes you can sneak that one in. Sometimes they can't prove it. There might be questions. And if you go back to a shooting situation, what if they can't prove who the shooter was? What if there are a bunch of people there? Nobody's talking. Somebody shot somebody. Maybe it was a bad shoot, but they can't prove who the person was. If you get on the phone and say, I was involved in a shooting, you've just given that up. If you say, there has been a shooting, which is what we've advised over and over again, you've now preserved that issue for us. Of course, there can be issues on the other side, right? You get the prosecutor at the trial, and if the defendant takes the stand. And of course, this is the kind of stuff you talk about in advance. We're going to be faced with this. Why didn't you identify yourself? They could try to say, well, you were sneaky from the beginning by saying there has been a shooting. But, there are ways to deal with that. I say, look, it was a quick call. It was a stress. I didn't think it was that important at the time. I just said there's been a shooting, send help, and click. Okay, so I think we can address that. But yeah, anything you say or fail to say kind of can be used against you in that 911 call, right? Remember, this is different than calling your lawyer, which is completely protected by attorney-client privilege. When you call 911, things you said and things you didn't say, all that's fair game. When you called, who you called after that, namely your lawyer. So that's why, we don't even recommend calling 911 in all circumstances. And again, this is another thing. about our program, I think that's really important. Because we can't give advice in every faction, at least let's just imagine we can give general advice, but we can't give the best, perfect advice for every unique factual circumstance. Because of that, the next best thing, you got to be able to get an attorney on the phone right now when you need an attorney. That doesn't mean you're calling some club that's going to promise to get you an attorney within 24 hours or at some time thereafter when they say, okay, who's on our list or something. That means when you call that emergency number within seconds, you are going to be speaking to not just an attorney, but an attorney who is at least on the defense team that is definitely going to be representing you. And I think that sometimes we don't make enough about the importance of this point about dealing with a law firm rather than a club.
Yeah, you remember when earlier in the conversation we were talking about assessing each individual situation and assessing each individual client. Talking to a client in that moment, you and I have talked to many people after emergency situations. Talking to a client in that moment allows us to make some judgments, right? And say, oh, okay, this person's freaking out. I mean, this person is in no condition whatsoever to do this, that, or the next thing. It allows us to ask the person to hand the phone to the cops or give our information to the cops so that we can talk to them. It allows us to remind them, a person who's maybe traumatized right now or in shock or doesn't really know everything, confusion, it follows these things. It allows us to remind them of some information that maybe if they were in a more calm state that they would remember more intuitively, like just shut up, don't make any statements, here's what you can do, here's what you can't do. Oh, by the way, put the gun down, put it somewhere, in this place or this place. Here's what you want to look like when the cops show up so you don't get shot, things like that. And to give legal advice that perfectly fits that situation. As you mentioned, Mark, we don't always recommend calling 911. And in fact, we have had a number of cases where a client luckily called our attorneys on retainer 911 hotline first, and we spoke to them, and we actually advised them, don't call 911.
I don't know if we're thinking about the same one here or not, because this has actually happened on several occasions.
Well, I'm thinking of about 50, actually, of ones that we've done over the years.
I took a call just a couple of days ago, and this particular person discharged his firearm. Somebody had discharged a firearm at him. He discharged his firearm back, and then he went home.
A gunfight.
And then he went home, and he called me, and I said, have the police been called? I said, not that I know of.
Were there any witnesses? Were there police been
called?
No.
Should I call the cops? I said, no, this is not a time to call the cops, because you and I have also had the benefit of many occasions where people have called the police in situations where we didn't think they should have been charged, and they were charged.
That's right.
I think a lot of people think that if you are the one who calls 911 first, the police will automatically consider you the victim of the crime. We've had many situations where the person who has called 911 and asserted, hey, I'm a victim in a certain circumstance, has then been arrested and charged with a crime.
Are you thinking of the recent one that I handled where the guy was the property owner in downtown, and he owned this property, and somebody broke into his property and ran at him, and he discharged a firearm as a warning shot into the ground, and then the cops showed up, and guess who they arrest? Our guy. Well, you used a gun, and he ran at you, and so got charged with felony. Luckily, we were able to, after he got charged with the crime and it dragged on for 4 or 5 months, we were able to get an excellent result there. But yeah, it's crazy.
No,
don't assume that just because you think you're the victim, the cops are going to agree.
Yeah, I remember that one. I was actually thinking of a different one. And this comes up all the time in domestic violence situations. Husband and wife, boyfriend, girlfriend get in a fight, and they think that the first one who calls the police is going to be sort of the victim. And I've had many occasions where the person who calls the police is the one sitting in my office. So police are smart enough to recognize that people sometimes think, hey, the first one who calls 911, they'll present themselves as the victim. Police officers are generally savvy enough to sort through that one, and they generally look at the evidence. So identify yourself, not necessarily.
Best if you can get somebody else to make the call.
Yeah, I mean, look, first thing is I think a question, should you call 911 at all?
Right.
If somebody is laying down in your living room, if human life is in danger, is the way we like to say it, somebody's going to die if you can't get emergency medical services, an ambulance out there, then I think you need to call 911. Because if you don't, right, if you call your attorney first, although they can't bring up anything about that conversation, they can say, hey, isn't it true you first called your lawyer and then you called 911? So they'll sort of the implication there will be that the attorney then convinced you to call 911 and that's the reason you did. So if human life is in danger, we say call 911. If human life is not imminently in danger,
call us first.
Call us first.
Talk to a lawyer right then and there to assess your individual facts. You could be unnecessarily getting yourself charged with a major felony.
Yeah, skip over this unnecessarily generalized advice that we're about to give that applies to every situation. Skip over that and get customized advice from a lawyer who you're on the phone with, who understands your situation right now. Mm-hmm. That's really one of the many strengths of the program that we've put together with Attorneys on Retainer that, to my knowledge, nobody else has.
24-hour, 365. You're going to be talking to a lawyer if you call that AOR.
I wish people knew how seriously we take this at our firm with our strike force. We have a video out there. Maybe we'll put a link out there to the strike force video, but we're not taken by surprise when somebody calls the emergency line at 2 o'clock in the morning or Christmas Day or New Year's Day or Thanksgiving or whatever. We are ready for it, and we are well prepared. We have teams who are on call and standby backup teams. Like, we're going to get that call. You are going to be on the phone with an attorney to get customized advice. Okay, so now that we've hit that, let's talk about the general stuff.
Well, yeah, and I also don't think that you necessarily, just because we were talking about that other video from Armed Attorneys we watched, I obviously disagree with give a short, truthful statement about the incident, and I guess we'll take some time on that. I also disagree with you should tell them the services that you're requesting. I don't necessarily agree with that in all situations. In fact, I can think of several important hypotheticals that we may or may not have seen in real life where that's not necessary. I think less is more in all respects here, but I guess to first tick off these boxes, we've said this so many times, Mark, which is that whenever you start making statements to the cops or 911 or anything like that, and start saying statements like, I was in fear for my life, I was being attacked, things like that, all you are doing is foreclosing different avenues of defense that your future defense attorney would have been able to use had you just kept your big mouth shut.
I don't want to assume people know this, but when you call 911, your statement is definitely recorded from the beginning, and every single thing you say can and will definitely be used against you.
And even things that you don't say. If you choose to waive your Fifth Amendment rights and speak to police or start making a bunch of factual statements to a 911 operator, then all that's going to be admissible potentially, probably, and they can make implications about things that you didn't say in that horrible moment of stress.
If you're saying things, now we're really talking to the police at the scene. They don't have a body camera running. They're just taking notes. We have definitely had many occasions where the police report says, and then the defendant told me, comma, quote, and then they put a statement in quotes, end quote. That statement in quotes, what does that mean? That means the officer is going to get up on the stand at your trial and say, I specifically remember that defendant telling me this statement. That's why I put it in quotes. I've had that. I've also had that in situations where the statement was recorded, and you know what? The client says, I never said that. And I've gone to the recording, and the recording reflects he didn't say that. So this is an honest mistake by the police officer, right? And fortunately, this was a gun case and a discharge, and it was looking at lots of prison. Fortunately, we got the recording. The recording was preserved, and we got it, and I got the prosecutor to listen to it. He said, yeah, that was the worst statement in the whole case. My guy would have gone to prison if the prosecutor believed he had made that statement, but he didn't. And
so take those same principles of caution is what I'm recommending, and use it when you're speaking to 911. And Mark, you and I have had times before in cases where we've requested the 911 911 call, and lo and behold, for whatever technical reason or whatever was going on with the technology, the 911 call wasn't properly preserved. The recording wasn't properly preserved. And now we're in the situation where, kind of like that particular client was, we're just hoping that that dispatch operator is going to remember everything accurately.
All these things are true. And that's why less is more.
Yeah, absolutely. So you don't want to foreclose other defenses, as I mentioned. Maybe there's a third party who you were trying to protect. Maybe it's one of these other state-specific statutes like the one in Texas that you were just talking about, using deadly physical force to protect property. Maybe it's something like a general crime prevention statute, which a lot of states have. Everybody should check your own state and see what you're equivalent of. But most states have a statute that says you're allowed to use deadly physical force to prevent one of these following very serious crimes that is currently in the process of being committed. You can do it to end the commission of that crime, and then there's usually a list. Check your state. But notice that specific type of a statute has nothing to do with being in fear for your life. Neither does that third-party defense one, and these are all situations where you can validly use self-defense. My question is, why on earth rob your future defense attorney of all of the defenses?
Yeah, I like to tell people, your job is to make my job easier.
The state is the one with the burden. They have to prove beyond a reasonable doubt. You don't have to open your mouth as the defendant. Why on earth make our job more difficult?
Okay, so just to recap here. If human life is in danger, call 911. If you can get somebody else to call 911 instead of you calling 911, I like that better.
Mm-hmm.
If there's another witness there, you got someone else who can call, a friend, have that person call 911. You can't call your lawyer and have your lawyer call 911. We can't do that because we can't independently confirm the truth of what happened. So we can't call 911. We don't want to be witnesses in the case or anything like that. If there's nobody else, then you got to call 911. We say if you can avoid identifying yourself, avoid identifying yourself. Hi, here's the location. There's been an incident. Please send help. Goodbye.
Yep.
And then hang
Click.
up.
Yep.
Because these 911 operators are trained, understandably, nothing evil going on here, but they're trained to keep you on the line. They have lots of things to deal with. They got to assess the person. They got to make sure the scene is safe. They're trying to get information for those officers who are now rushing to the scene. And then we always tell people, if you're going to call 911 and then hang up, you know those police officers are coming. Their attitude is, I'm going home. The last thing you want to do is look like a threat when they get there. Mm-hmm. Make sure, if it's a firearms case, that firearm is not in your hands. It is far away, the scene is secure, and you do not appear to that police officer as a threat. You can lose your life in this situation. So your goal after hanging up that phone, and again, if you got time, you call us and we will tell you this, is to make sure that you don't appear to be a threat. So you do have to give your location. We agree with the armed attorneys there. They
Correct.
say you got to give your location. Yes, you got to say here's where the thing happened. In terms of identifying yourself, not so sure about that. Request police and ambulance. All right. It doesn't give you a lot of heartburn if you say request the police, we request help, ambulance.
It's not uniform, though, in all situations, and this is one of the reasons I keep bringing it back to the fact that it's really important to have an attorney right there in that moment to do a customized assessment of your situation to tell you exactly what's the best in that
What
moment.
if it's an accidental shooting or something? And
what if you don't know you hit them?
Right. Yeah, there's all kinds of questions.
Oh, the fact that you called the ambulance and asked them to send EMS is proof that you knew that you shot them. Maybe that's your defense is you didn't know that you hit them.
And why are you asking for police? You're essentially saying, I knew there was a crime here that was committed. So,
Right.
Again, call the lawyer if you can call the lawyer first and avoid the situation. Okay. And then there's the reason you are calling. Man, that one gives me a lot of heartburn. And I understand, again, what Richard and Edwin were trying to say in that video. Because, look, if you could imagine a set of circumstances, if you could craft that statement perfectly, where it would be to your benefit to sort of set things up a little bit. But it's really hard to give that advice and expect people, first of all, to stick with it, right? Because the second you give that short statement, oh, I don't understand what you mean by this or that. Can you explain this a little bit more?
Right, the 911 operator who is trained to keep you on the phone and get as much information as possible. Most people calling in after a stressful situation like this aren't going to be able to deflect, and they're going to think, oh, okay, well, it's okay to say this or this. I've already said this and this, so I might as well say this and this. Don't put yourself in that situation.
Yeah, I think it's really hard. And, to be fair, we have had gun cases at our firm where not only have we advised our client to make a statement, we've called a press conference on it.
That's right.
And I've made a statement. My client has made a statement. We've brought other sort of Second Amendment activists in. We call the press, and we're making a statement to the whole world about what happened. But that's after.
This is, of course, after getting all of the evidence and carefully going through everything with a fine-tooth comb and making an educated decision on what to say.
Yeah, we're not saying you should never make a statement. What we're saying is don't make it right there at the scene before you have consulted an attorney, reviewed all the evidence, thought carefully about whether this is in your interest. There's plenty of opportunities to make statements. You could make a statement the next day. You could make a statement at any time between there and your trial. You might make a statement for the very first time at trial. That's kind of my favorite, because why tell the prosecutor what the statement is going to be in advance, essentially showing them your cards and then let them deal with a response? I like to say we haven't even decided if the defendant is going to testify. We don't have to make that decision until right in the defense case when it's time. For the first time, we could say, Judge, my client has decided to testify. You can make a statement right there and then after the state has presented its case in the defense case for the very first time.
Yeah. In that particular video with the armed attorneys that we keep referencing, they were playing a phone call from a fellow named Joe Horn, which is a very famous phone call, very famous 911 phone call, where he spoke to 911 for, I believe, over 8 minutes. It's a long phone call. And the gist of it is that he saw somebody breaking into his neighbor's house and stealing a bunch of items. As he put it, I believe he had a bag of loot that he was taking out, the bad guy was stealing from his neighbors. He had a long conversation with 911 where he's basically watching it in real time and keeps arguing with the 911 dispatch that I want to go outside and I want to help defend their property. I got my gun with me. I'm going to go outside. And the dispatch keeps saying, no, stay inside, don't go out there. Eventually, he goes out there and he uses deadly physical force.
You can hear the shotgun, right? Yeah. You can hear him chambering a shell in the shotgun. That very unique sound that a shotgun makes, it comes through on the 911 call. Look, this guy got very lucky, right? I mean, clearly it's a property crime. Now, again, we can't tell from the 911 call, and I don't know exactly what happens after he goes outside. Could still be justified.
Absolutely, yeah.
Yeah, we don't know what happens at that point. But he certainly did insert himself into the situation. I would say it's a good thing this happened in Texas and not in New York or Maryland or New Jersey or one of these states. This guy definitely would have been indicted, no question about it, but he didn't get indicted. I got to say, look, I have some sympathy for the guy. I like this guy. I don't mind a neighbor like him.
Who doesn't want a neighbor like Joe Horn?
Yeah. I mean, he's the kind of neighbor you want, I think. Maybe a tad reckless, but okay, fine. But again, not the way to handle the 911.
Yeah, my critique is not necessarily his actions, like what he did with the firearm and wanting to look out for his neighbor and everything like that. My critique is that he didn't do himself any favors with that 911 call, and frankly got exceptionally lucky that a grand jury made the right decision here. But you're right, Mark. Any other jurisdiction, this guy'd probably have some serious problems.
Yeah, I think so.
Yeah, and he definitely didn't help himself with that 911 call. So I guess, in summary, in my opinion, if we accomplish anything with this video, is to encourage people to take that same protectiveness, like a good, competent gun owner knows, and just people and just citizens in general should have an air of protection that they have against their own well-being when cops show up at a scene of a crime and start asking questions. Okay, yeah, a lot of people blurb and everything like that, but at the end of the day, people who are educated on the Fifth Amendment and educated about the criminal justice system have the wherewithal to say, sorry, officer, I'm not answering any questions without my attorney. I want my lawyer present. if we accomplish anything with this video today, it's to encourage people to take that same protectiveness and self-preservation that they feel when cops start coming around and asking questions about an incident, and simply apply that same sort of protectiveness to the 911 dispatch. You give as little information as possible that'll get the response coming without incriminating yourself.
Yeah, I think it's a very important point. You do have a right to remain silent. The fact that you remain silent and even ask for your lawyer is definitely not used against you. It's not something that comes into the trial. So you're not doing anything wrong. Police officers understand how this works. Indeed, I've represented many police officers over the years. I used to do some FOP, Fraternal Order of Police, representation of police officers. And police officers teach their own kids to just shut up.
That's right.
Police officers give each other the advice after a shooting to just shut up. That is the advice. So if you're dealing with a halfway decent police officer, and most of them are, they're going to understand, even agree with, and accept the fact that you're saying, you know what? I'm not going to make any statements right now. I want my attorney.
Well, they don't
present.
have a choice, whether they like it or not, frankly. Maybe they really don't like it. Maybe this is a bad cop, or maybe it's a cop who's just particularly zealous and wants the conviction that they've already concocted in their mind. They don't have a choice. When you invoke your Fifth Amendment rights, all questioning must cease.
Yeah,
and you and I have actually had some cases before where the cops didn't follow that rule. They made an unequivocal, legally sufficient invocation of their Fifth Amendment rights. And the cops continued asking some questions, and you and I have been in front of judges before saying, this is an outrage, Judge. This is a basic fundamental right. We want all this evidence thrown out.
It's worth a tad bit of a segue here just to say there is a difference between saying, I got nothing to say, I'm going to invoke my right to remain silent, and saying, I want my attorney present.
That's right.
I want my lawyer. Again, it's got to be unequivocal, right? You got to be sure about you. If you say, should I get a lawyer? Or I think I need a lawyer. That doesn't count. So it's important to bring the word lawyer into it in an unequivocal way. Why is this important? It's the difference between whether the police can continue to ask questions. If you just say, I invoke my right to remain silent, they can then say, well, why would you do that? I mean, if you're not guilty of anything here, we think you're the innocent guy. They can go on and on and on. They can work
keep
on
questioning. And that's what the Fifth Amendment provides you. But yeah, what you're talking about is getting the Sixth Amendment involved.
I want my lawyer present. Then they got to shut up. If they continue to work on you at that point and you eventually crack and you tell them some kind of a statement, we have a very good argument to get that suppressed.
Absolutely.
Okay, so I guess the takeaway here is don't go it alone. Right? If you find yourself in this situation, hopefully we have laid enough out here where you say, you know what? I should probably get some people who do this for a living and have been doing it for decades on the line right now. I mean, if you're a client in the AOR program, you can definitely do this, where this is what we're set up for. The emergency hotline is a big part of being in the Attorneys on Retainer program. So
it's a huge selling point for a lot of people. Will join the program specifically for that reason, because no other service on the market offers that.
So don't guess here. Call us and we will advise you. We'll give you our best advice on what to do. But imagine you're not a member of the Attorneys on Retainer program.
Then go sign up.
Yeah, you probably should sign up. But if you find yourself in a situation and you got nobody to call and you have to go it alone, less is more.
That's right.
And so call 911 if somebody's going to die and there's been an incident. You don't even have to say what it is, right?
I wouldn't say what it is.
There's been an incident. Please send help. We need emergency services. You could say somebody's bleeding out or something like that. I don't know. Here's the location. Goodbye, click. And that's it.
Yeah.
And then call an attorney if you got somebody you can call. If human life is not in danger, you should call an attorney and get some professional advice on what to do.
Yeah, I don't even agree with all the advice that you just gave, because I don't think it's a good idea in all situations, even if there's somebody on your floor bleeding out, for you to say somebody's bleeding out. I wouldn't even say that.
You're like, there's just been an incident, send help, goodbye.
Yep, just been an incident. We need emergency services immediately at this location, goodbye.
All right. right. I think I could go with that. I think I'm fine with that.
But sometimes it makes sense. This is why you need custom kind of in-the-moment advice.
Yeah, I mean, because, again, if it turns out that it's very clear that the guy was bleeding out, you're standing right there, why didn't you say that?
They don't want to. You don't want the prosecutor to try to say, okay, well, you weren't really trying to save the guy's life by calling 911.
Yeah.
So once
would have been helpful to the EMS to know somebody's bleeding out on the floor rather than any of the other countless things that they could be coming for. So I don't know.
You see that? Like, even reaching this, we have like certain situations where if you tweak the facts just a little bit, there's better advice that you
That's
can
why
get.
the best advice is if you can get an attorney on the phone as quickly as possible.
It goes right back to that very first thing that we opened up this video with, which is there is no blanket statement like, here's the best thing. All we can do is speak in generalities.
Yeah, you can give me any kind of statement from any lawyer, and you and I can find a factual circumstance where that's going to hurt you if you say that.
That's right.
We can play this game, right? So that's why we say less is more.
And I feel like we've had everyone in the books.
Right. We've had so many twists and turns on this one issue. But again, and we're putting this out to the general public, right? And so in that group, there are people who are very sophisticated and people not very sophisticated. People who handle stress well and people who don't handle stress well. People who recall facts down to the small detail and are able to articulate them carefully to a police officer, and others who don't. Where did it come in the house? Over there. Pointing, it could be the window, could be the door. I mean, so people...
And that could be that fact right there, that statement right there could be the difference between whether it's a strong case or a weak case.
Where did he break in? He came in from over there. Officers, he pointed at the window. He said, no, I was pointing at the door. No, I'm sure you pointed at the window. This could be the difference between an acquittal and just doing 10, 20 years.
That's right.
So why put yourself in that position?
Less is more.
So I hope we sufficiently confused everybody to the point they're going to say, you know what, I'm not going to say anything if I don't have to.
That's all I was trying to accomplish in this video,
Yeah.
and I hope we did. And also to emphasize the importance of having a lawyer in an emergency situation to answer your questions and give you customized advice that actually fits the specific factual situation that you're in.
Say as little as possible if somebody's going to die, get the help there, then call an attorney and get something that is custom made for your facts and circumstances.
All right, I agree with that. All right, everybody, go and check out attorneysonretainer.us and sign up to have an attorney available for you 24/7, 365 in case, heaven forbid, you're ever in a situation where you need our help. We're there. We are seasoned in this area, and we're the reason why our program is different, because you're going to have lawyers there for you when you need us the most. If you want to learn more about us and our law firm, go and check out attorneysforfreedom.com to learn all about the philosophy of our law firm, who we are as attorneys, and how we represent people in court. And remember, if you enjoyed this video, like the video, subscribe to the channel, and leave us a comment or questions down below. Until next time, this is Attorney Andy Marcantel and Attorney Marc J. Victor.
Peace.